whether this firearm enhancement applies in this case. And I'm going to tell you, they're charging him with two different theories. Misdemeanor manslaughter based on negligent use of a firearm. You absolutely cannot add the firearms enhancement to that. The mandatory prison does not apply to that. The New Mexico Supreme Court came out back in 1993. I'm looking at the decision right here. State v. Franklin. And in State v. Franklin, this was a case where there was two kids. They were friends. They were sitting out there, and they were playing quick draw on a Sunday during a football game. They just kept drawing their firearms at each other. Yeah, it's pretty stupid behavior. Pretty stupid behavior is what you see in involuntary manslaughter cases. You know, this criminally negligent behavior, it's got to be really above and beyond. It's not just you had an accident. It's how stupid could you be? Of course somebody was going to get hurt here. And one of the kids shot the other one and killed him. And it went to trial. And at trial, the prosecutors were trying to add the firearms enhancement to the same exact charge that they're bringing against Alec Baldwin. Involuntary manslaughter because you committed negligent use of a firearm misdemeanor. Okay, that's one of the theories. And the trial court struck the firearms enhancement. They said, no, if you're charging somebody for involuntary manslaughter through negligent use of a firearm, the firearm enhancement can't be added on because the firearm itself, all of that is subsumed into the involuntary manslaughter charge. You can't add the firearm enhancement to a firearms crime. And the DAs actually appealed that. They said, what? No, we can add that. And the New Mexico Supreme Court came out, or actually the New Mexico Court of Appeals, but this is a binding decision. Binding meaning the lower courts have to follow this. They came out and agreed with the trial judge. They said, if the basis of your involuntary manslaughter charge is a misdemeanor firearms count, you cannot then, what carries an 18-month probationable prison sentence, meaning the judge could give probation or could give prison, you cannot turn that into, oh, it's 18 months discretionary with a 1 to 5 years mandatory prison. So the guy has to get at least 1 year in prison. We're not letting you change that into it. The legislature didn't intend that to happen, and we're not going to allow it. So they absolutely cannot add the firearms enhancement to the first theory of liability to Alec Baldwin. So it's 18 months of prison time if he's convicted at trial, and the judge has discretion to give him probation. He's going to get probation for all the reasons I just talked about. Well, in 1996, if we go down, and this is how law gets shaped. You know, when I first went to law school, I thought everything was black and white. Comes out there's a reason why you have lawyers. And the reason why you need a good lawyer is because everything is subject to interpretation, and your lawyers go in there and advocate for your interpretation. And there's still stuff that needs to be interpreted here, and this is what we're getting to. When you get to the second theory is involuntary manslaughter because you did something without due caution or circumspection. So it's not because of a firearm, technically. Now, they're going to say to wit at the end of that charge. They're going to say to wit because you basically handled a firearm in a crazy way and you shouldn't have done that. But they've never had a decision that came out and said, well, if you're basing involuntary manslaughter not on misdemeanor negligent use of a firearm, you're basing it on the criminal negligence part just generally without circumspection, and it's because of a firearm, they haven't addressed that specific issue of whether you can add that firearms enhancement on or not. What they have said is this. Look, we need criminal negligence, so it has to be recklessness. And we have said this, that in an aggravated assault case, where it's just aggravated assault, and you're saying it was done with a firearm, you can add the firearms enhancement to that. So this is what I mean. The law is kind of all over the place. And so what's going to happen in the Alec Baldwin case is I could imagine that the DAs, especially for leverage purposes, you're trying to get him to plead guilty. You want him to be facing mandatory prison. So we're going to add the firearms enhancement to the second charge without circumspection. And the attorneys for Alec Baldwin, if they're any good, they're going to try and appeal that before trial. They're not going to wait till after trial and after conviction to go, we want to challenge the firearms enhancement. No, let's challenge it up front. Let's get a ruling from the higher court. And this is a case where the higher court, you don't know what they're going to do, and I don't know what the makeup of the New Mexico Court of Appeals or Supreme Court is, but just based on public policy alone, are you going to be able to change involuntary manslaughter, which is it's a crime without intent? You don't have the mens rea, you know? You don't have the intent to actually hurt or kill somebody. Are you going to be able to change that into a mandatory prison firearm offense every time that you use the second theory, which is basically you used a firearm without due care, which is basically the same thing as negligent use of a firearm, but we'll just charge it under the second theory, and we can start adding firearms enhancements to all those cases. So let's just forget about the misdemeanor manslaughter rule. If we want to put firearms enhancement on every case, forget about misdemeanor manslaughter. We're going to go everything through without circumspection, without due care and circumspection, without caution. We're going to do everything under that theory. And I could see as a judge, as an attorney right now, and a former prosecutor, I have a problem with that. Okay? I'm all for, but this is what prosecutors do. And this is the way the law gets shaped. So they're not doing anything wrong, right? But if you give them a ruling where they can add that on to every single case and forget about, the 1993 decision, State v. Franklin, they could go back to State v. Franklin and go, man, that kid that shot his friend on a Sunday, we could have got that firearms enhancement if we just would have charged him under without caution and circumspection, to wit, used a firearm. We just charged them with the wrong one. If you give them that kind of power, they're going to use it. And they're going to use it. Why? Because in order to extract pleas out of people and not have to go to trial, because it takes so much resources and the system would crumble if you had to take everybody to trial, they need leverage. So that's going to be an issue here. So whether he can really face the firearms enhancement or not is an issue that still needs to be settled. I see attorneys on TV saying, oh, it can definitely come under the second theory. I see attorneys saying it can't come under either theory. The truth is, we don't know.